Progress.
You may be seated. Mr. Rusche.
Thank you, Your Honor. Ryan Rusche, again, attorney for the tribes. The compact parties demonstrated in our briefs that most, if not all, of these objectors' rights are protected from call. To the extent that they are not, objectors have not demonstrated how any specific component of the tribal water right impacts any specific right of theirs. And specifically, Your Honor, we address those at docket 1894, pages 7 through 8, docket 1929, pages 22 through 23, and docket 2061 at pages 15 through 16. Judge, before the court is a settlement agreement. It resolves years of costly, uncertain litigation. It was negotiated in open public forums over the course of many decades. It was ratified and approved by the executive and legislative branches of 3 sovereigns who heard all of the same complaints discussed this morning. Under the appropriate standard of review, the compact parties have satisfied their burden and shown that the compact is a good faith, arm's length agreement that's consistent with applicable law. Shifting the heavy burden to the objectors to show that the compact is illegal or unreasonable and that it's the result of, and that as a result, they were materially injured. Attempting to meet this heavy burden, objectors tried to rewrite the law, particularly with respect to Indian Reserve water rights, rewrite the history of the Salish, Kasanka, and Clisquet people, or otherwise erase them from their own home, and the very way of life that they reserved and protected under the Hellgate Treaty. The court should not deny all of objectors' motions, grant the compact parties' motion for summary judgment, and decree the compact. Thank you.
All right, anything further from the compact parties?
Your Honor.
All right, any rebuttal based on that statement? All right, Steve. Mr. Jore. Again, for the benefit of the self-represented parties, rebuttal means addressing the response, not to raise new arguments that weren't raised before.
Thank you, sir. To the extent that I heard, and I hope I heard correctly, there was an issue of challenging any claim of injury, that we were not documenting any injury, and my initial response would be James Madison's definition of property comes to mind, where he contends that, as it can be said that a man has a right in his property, it can also be said that he has a property in his rights. And pertaining to my argument of due process, the right of due process in Madison's term there, context definition, a diminishment of representation, it would be a material injury in my mind. So,
thank you, sir. Mr. Shire. Shoening. I apologize.
That's okay. I've lived with that my whole life.
Okay.
So I have a question for the court. All right. I was expecting immediate rebuttal when I gave my talk, and so there was something I would like to correct in the record that Objector Sowers' rebuttal remark was made. Can I do that?
I'm trying to understand. So are you making a factual correction, or are you trying to...
Yeah, factual correction. Like, for example, what happened was Ms. Sowers brought up the fact that the Holmes case in 1931 dealt with the situation involving...
All right. So I'm going to stop you because I want to maintain some control over this and some decorum about how we do things. And that was, if there was rebuttal, it was up to Ms. Sauer to do the rebuttal because it was her motion. So I think we're good with what we have right now.
All right.
All right. So
okay, but I did have something with mine. Can I bring that up?
As long as it's in response to something the compact parties just said.
Had to do with fact.
All right.
So the court needs to determine fact, whether we're talking about a permanent homeland or a home. Which is it? So this is a classic fact that I wanted to be adjudicated on. Okay?
Okay.
Thank you very much, Your Honor.
All right. That concludes all the motions that were on the court's docket. Obviously, there are a lot of briefs that have been filed. There are other motions pending or responses that weren't argued, but as I indicated in my order, that doesn't mean that they will not be reviewed by the court and taken into account. The court will issue either an order or orders on all the pending motions in due course. I can't promise you how long that'll take. There's a lot of material, a lot of new and helpful elaboration and discussion was had over the past 2 days, and I do appreciate everybody's time that they put into it. It's extremely helpful for the court. And I know you all put a lot of time into it, and this is a very important matter, and I do appreciate that. So thank you for the arguments, and with that, we are adjourned.
All rise. All rise.
I mean, the roof is good, the siding's solid, the windows, there's 3 windows that need replaced. A sink in the bathroom needs replaced, the toilet needs replaced.
Recording stopped.